A Las Vegas investigative reporter is brutally stabbed to death outside of his home. The man accused of the heinous slaying is a politician who is at the center of his reports. Jeff Gehrman was a local legend in the Las Vegas area, known for his reports on infamous mobsters, murderers, and crooked politicians. According to his co-workers, Gehrman wrote about terrible people who have done awful things for over 40 years. So when Gehrman was discovered lying outside of his home with multiple stab wounds, 4 of which were to the neck, there was a list of people investigators looked at who they thought could have been connected to the killing. But one name seemingly stood out in the bunch, and that was Clark County Public Administrator Robert Tellis, who Gehrman had written a number of articles about. According to Gehrman's reports, Tellis displayed hostile behavior at his office. Many of those who worked with the former public official believed he was acting as though he was above the law, and even accused the county of turning a blind eye to Tellis's actions. So they turned to Gehrman. The journalist reportedly first learned about the accusations of a toxic workplace from 4 female employees, one of which was Rita Reed, his former top assistant, who called Tellis a horrible human being and a monster. Tellis's elected position was to administer wills and estates for Clark County. But Gehrman reported Tellis bullied his employees and even had an inappropriate relationship with one of them. While Tellis denied having the improper relationship and that he mistreated his employees, he later lost his primary bid for re-election. In response to Gehrman's many reports, Tellis fired off a series of tweets calling Gehrman directly a liar, referring to him as a wild animal, and claiming Gehrman was obsessed with him. After Gehrman's horrific murder, investigators had several clues that would trace back to the former public official. 2 days after Gehrman's murder on September 6 of 2022, authorities released this surveillance photo showing a person wearing an orange reflective shirt and a large straw sun hat, similarly to a landscaper. 2 days after the photo was released, authorities released surveillance video of the suspect, as one of Gehrman's co-workers noticed the video reminded him of a walking shot he had taken of Tellis when Gehrman interviewed him at his office. Then another clue. Authorities released a photo of the suspect's car, a maroon Yukon Denali. Investigators quickly received tips that Tellis also had a car that looked similar to the vehicle, which turned out to be registered to his wife. This would prompt Gehrman's colleagues at the Las Vegas Review-Journal to go to Tellis's home. And when his colleagues arrived to the politician's home, they witnessed Tellis walking out of the driveway where the maroon Yukon Denali was parked as Tellis began washing it. Then in the early hours of September 7th, 5 days after the murder, Tellis was brought in for questioning as police searched his home and cars. They also collected a DNA sample from Tellis. According to investigators, a gym shoe and duffel bag were collected as well, which resembled what was seen in the surveillance video of the suspect. Plus another startling clue. Investigators also searched Tellis's garage and found pieces of a cut-up sun hat similar to the straw hat the suspect was seen wearing. Then arguably the biggest clue came from a DNA sample that was taken from Tellis himself, as DNA results showed Tellis's DNA was found under Gehrman's fingernails. Authorities zeroed in on their murder suspect. However, when police arrived to arrest Tellis, he reportedly refused to leave his home. According to CBS News, Tellis made comments associated with self-harm, which prompted SWAT to move into his home. After, Tellis was rolled out of his house on a stretcher and was taken to the hospital for self-inflicted injuries. 6 weeks after, Tellis was booked into the Clark County Detention Center and was indicted by a grand jury for murder. Tellis pleaded not guilty to the shocking crime, and although he faces a first-degree murder charge, which could carry the ultimate punishment of death in the state of Nevada, prosecutors announced in October of 2022 they won't seek the death penalty against the former politician. Then in a February 2023 interview with news outlet KTNV, Tellis denied killing Jeff Gehrman and even claimed he was framed for the journalist's murder, despite having no proof he was framed. He claimed the physical evidence police found at his home was planted. And Tellis claimed he wasn't the person who appeared in the surveillance video at Gehrman's house the day of the murder. Weeks after the interview, the former elected official said in court he was planning to represent himself after cycling through 4 defense lawyers and with hopes to speed up the trial.
You understand that it's almost always more wise to be represented by counsel.
I do.
Especially when you're being charged with first-degree murder and facing life without the possibility of parole.
Yes, sir.
Right?
Yes.
But during that February 2023 hearing, Judge Michelle Levitt was quick to point out Tellis's lack of knowledge about criminal cases.
You just indicate you want to represent yourself for a couple months. I mean, I am not I am not playing games with you.
I
This is
understand.
very, very serious. You
I
are
understand.
charged with first-degree murder.
I understand.
I mean, you're facing life without the possibility of parole. I would think that you would take it a little more serious. It is not a game. I will not allow you to treat it as a game. And you're a lawyer and you know, oh, I want to represent myself for 2 months until I can get a new lawyer. You want a new lawyer? That's fine. I'll give you time to hire a new lawyer.
Yeah, unfortunately, I cannot, I would prefer to represent myself.
Okay, and you know anything that you say, period, can be used against you.
Yes, sir.
Okay, I just wanted to make sure you understood that, because I wasn't sure you did.
I absolutely have.
Okay,
It is very
and
clear.
anything that you say, the state's gonna know about it, and it can be used against you at the time of trial. You understand that, right?
Absolutely clear, Your Honor.
Okay. Do you know, you understand what the charges are against you? Do you know about any possible defenses to the charge? You can just say yes or no.
Yes.
Okay, you understand that you would be required to develop that defense
Yes.
before you put it on in front of the jury, correct?
Yes.
Okay, and you understand an attorney can research the law for similar cases and present possible defenses to these charges?
Yes, sir.
Okay, and you want to do that yourself?
Yes, sir.
Okay, and again, you understand that, it's the ultimate punishment if you are convicted of first-degree murder, right?
Yes,
If-
sir.
And you understand that life without the possibility of parole in Nevada means exactly that, life without the possibility of parole. You would spend the rest of your natural life in the Nevada Department of Corrections.
I understand.
Okay, I just wanted to make sure that you understand that life without means exactly that. Okay, do you know the difference between an opening statement and a closing argument?
Yes, sir.
Okay, tell me what the difference is.
In the opening statement, you give a general outline of where you expect the case to go, without being too conclusory. And then, of course, in the closing arguments, you specify what facts related to your opening argument, what facts prove your own argument or tend to prove your own argument. And then you, of course, let it go to the decision maker from there.
Okay, and do you know how to object to a question that may be improper?
Yes, sir.
Okay, how do you
You
object?
state the objection and then, of course, the reason for the objection.
Okay, and so you understand that the rules of evidence are extremely important in a criminal case.
Yes, sir.
And I'm assuming that you have experience with the rules of evidence.
Yes, sir.
That in a criminal context, there are differences. You understand that?
Yes.
Okay, but you also, again, you don't have any experience in practicing the rules of evidence in a criminal context, except, in those misdemeanor cases, did you actually put on bench trials?
No, they were flat out.
Okay. All right, so you've never done even a misdemeanor criminal trial?
No,
Okay. And you understand that if you choose to represent yourself, you're still going to be required to follow all the rules of evidence, all the rules of criminal procedure, even if you don't know what they are.
Yes, sir.
Do you understand that? And I can assure you, Mr. Sheets knows what they are, the state's attorneys know what they are, and you'll be charged with knowing what they are.
I understand.
Okay, and you understand if you choose to represent yourself and you don't get a result that you like, you understand you can't say on appeal, I was bad at representing myself.
That is, I understand that.
Okay, and you understand any post-conviction, so you waive certain issues. You waive ineffective assistance of counsel because you can't argue that you were ineffective in representing yourself. Okay?
Yes.
And you understand that you can't argue on direct appeal. I do a very good job representing myself.
I understand.
Okay, because I don't think anyone ever does a good job representing themselves. It's always better to have someone that's objective and unbiased that can give you the appropriate advice. And I know you're a lawyer and you think you can represent yourself, but I don't think it's ever a good idea to represent yourself. I don't think it's a good idea to represent yourself in a misdemeanor case, let alone one where the consequences could be as severe as restricting your liberty for the rest of your life. Okay? I just want to make sure you understand that.
I do.
Okay? And you understand that once you decide on self-representation, you don't get to change your mind in the middle of the proceedings and request an attorney?
Yes, sir.
Because I think I made it pretty clear we're not playing games here.
Right.
And that even if you represent yourself, you're probably not gonna get that trial date moved up.
Okay, yeah.
Okay, because again, I really think that that November date was an aggressive trial date.
Okay.
So, I mean, we're already in almost March. You know, I mean, it might seem like a long way away to you, but getting prepared for a trial of this magnitude, that's a very short period of time.
I understand.
Okay.
Then earlier this year, Tellez accused Judge Levitt of misconduct and wanted her removed from his murder trial.
So first I'll discuss Judge Levitt's deep-seated favoritism, and I'll finish by discussing why she's engaging in this misconduct. Now, I understand that Your Honor might be inclined to grant or, to give her the benefit of the doubt. However, Your Honor, the misconduct that's occurred here is well outside the bounds of any reasonable doubt. Judge Levitt, her favoritism is so deep-seated, she refuses to refrain from violating constitutional rights, and in turn, she's wasting taxpayer funds, and she refuses to acknowledge that as well. When, Judge Levitt engages in intentional misconduct, often the resources of the appellate courts, additional resources of the state, and additional resources of the public defender are wasted. And that's not to mention when often those who are wrongfully convicted have to bring civil suits. Now, all of this comes out of the taxpayers' pockets, and given that Judge Levitt has refused to stop violating constitutional rights, it seems she just doesn't care. And so, what I think what is important here is to point out that it's, this has got to stop. Here, a reviewing judge strikes all unlawful probable cause statements and then reviews the statements that remain. If there is not substantial probable cause at that point, the search warrant is void and the fruits of the search are tainted. Here, I demonstrated that constitutional precedent required the striking of the majority of the statements in the officer's affidavits. I should have prevailed in obtaining that hearing, and at which I should have ultimately prevailed in demonstrating that the search warrants were void. However, Judge Levitt did not like that outcome, so she willfully defied constitutional precedent that required the striking of those statements. But what Judge Levitt did essentially was she ruled that when you took these illegal statements and you put them all together, that combined, they no longer violated constitutional law. Now, furthermore, Judge Levitt had prior said that she would set that hearing as soon as the motion was filed. On the day that I expected that Judge Levitt would set the hearing as she promised, Ms. Weckerly stopped my advisory counsel in the hallway before the hearing, and she told him that I would not be receiving that hearing. Then, in the hearing, just as Ms. Weckerly had predicted, Judge Levitt decided to refuse me that hearing after all. The only logical explanation is that Judge Levitt denied the hearing because Ms. Weckerly told her that there would be no avoiding the exposure of some, if not all, of the substantial police misconduct. Would an impartial judge defy controlling case law and renege on a promise to set the hearing just to protect police officers from lawful accountability? No, but Judge Levitt did. And Your Honor, I believe that if you do not disqualify Judge Levitt, respectfully, I think that it's going to send a message that, money can buy anything, even the wrongful conviction of an innocent man who's just trying to stop crime. So in order to protect my constitutional rights to prove my innocence, Your Honor, I'd like to ask you to please disqualify Judge Levitt. And as far as those reports, I've got copies here if you'd like to see them.
But Tellez's plea to the judge didn't work, and Judge Levitt will continue to preside over his case. After a year of representing himself in court, Tellez and his family hired a defense attorney to represent him moving forward. After several delays in the case, in part due to a legal fight between the Las Vegas Review-Journal and officials who seized Jeff Gehrman's personal devices after his murder, which reportedly contained confidential reporting information, and a report by the outlet, they say they're prepared to turn over information by Monday, the same day jury selection is slated for. As both sides gear up for Tellez's murder trial, the state says they have about 20 witnesses for the case, while Tellez's defense plans to call about a dozen witnesses. And at this time, it remains unclear if one of those witnesses will be Robert Tellez himself. Jury selection for Robert Tellez's murder trial is scheduled to begin on Monday, July 12th. However, ahead of jury selection, a hearing is also scheduled to determine if a trial delay is necessary due to the information on Jeff Gehrman's devices. If Robert Tellez is convicted of first-degree murder, he faces the rest of his life in prison with no chance of parole. Reporting for Law and Crime, I'm Elizabeth Millner.